All right, aloha everyone, and welcome to the November 24th Hemp Distributor and Retailer Info Session. I'm Andrew Goff. I am the Program Manager for the OMCCR. With me today is Greg Edwards, who is works on all things hemp with the OMCCR. He's your go-to guy for questions on what the hemp rules are and anything food related. Uh, Pharmacy related, all that good stuff. So today we're going to do a little bit of a different webinar. It's going to be basically going over what our proposed rules are. So this is the industry's opportunity to uh, preview what the changes that we are making and offer industry feedback on those changes. And that's something we'll take into consideration while we are finalizing the draft rules. So this is a webinar format. We have turned off the chat function, but if you have any questions along the way, the Q&A is live. You can type in your questions there. And then at the end, if there's time, we'll go over and answer any questions. And then, as always, if you have questions that pop up into your mind later, feel free to email us and let us know. So today we are going to go through the actual draft rules and what they look like and the rules that are the wording that's being proposed to implement HB 1482, which is now Act 269. We're going to open these up for comments for 1 week. We're going to send out everyone that's on this call a form to fill out on the internet. And basically, if you read the draft rules, we'll give you a copy of the actual draft rules, a full copy. They will say proposed, so they're not official, so don't act on them. Don't, they're all subject to change and uh, approval. So these are just where we are at in the draft in order for you folks to take a look and from an industry perspective, let us know if they're workable, if there's issues around that we haven't thought of, and if the language makes sense to you folks. So that form we're going to send out, and it will be open for 1 week to provide feedback. Let me just do this. So this is our landing page for our website. And this is the full OMCCR website. If you go to the hemp products page, the proposed rules and the form will be up in this update section for the week that they are open for comment. And then they'll also be in this tab, communications to industry. This is where we're putting everything that we've done in the past. You'll see the recording of the info session that we did previously, the news releases, and all of that. Also on this website, a list of our current rules. So if you want to go take a look at what the actual rules say currently, click on this. This is the latest version. I'll just give you a little preview for folks that haven't. The rules are a little complicated, but in general, we're looking at definition section. You always need to pay attention to your definition section. Section 3 is the prohibitions. This is where you're going to find all of the form prohibitions where you can't sell hemp vapes, you can't sell hemp concentrates, hemp flour. All of that is going to be in the prohibitions. Manufactured hemp products is where you'll find most of the product requirements. Edible manufactured hemp products is where you'll find the THC limits for each individual edible manufactured hemp product that we'll see. And beyond that, most of these rules are for processing. So the testing requirements that you'll see, the packaging and labeling requirements that you'll see. If you need a hemp processor permit, this is all the things that you'll need to know. Hemp processor requirements, processing facilities, quality control, GMPs, and enforcement. So in a nutshell, that's everything you need to know to process and sell hemp products. Under the current rules. So before we get into the rule changes, there have been some federal updates. I know there's a lot of questions around what the federal law is going to change into, what it means, and how we are going to change our laws to meet that federal rule. So we're just going to go over what the statute actually says. So, in general, it changes the Agricultural Marketing Act of 1946. So, it actually changes the statute. It's not just appropriation language. Basically, it separates cannabinoid hemp products from industrial hemp. It prohibits cannabinoid hemp products with greater than 0.4 milligrams total THC per container. That is an extremely low THC limit. And it prohibits synthetic cannabinoids, including uh, synthetic ones created outside of the plant. The specifics, so the THC definition was expanded to clarify that it's total THC. That includes all THC compounds, including THCA. It separates industrial hemp. It's now a distinct form, separate from cannabinoid hemp. It excludes from the definition of hemp, so these would no longer be allowed under federal law, seeds from marijuana plants. So if the plant itself was over 0.3% THC dry weight, any seeds from that plant would now be prohibited. Any hemp-derived cannabinoid products with cannabinoids that aren't naturally produced in the plant or that are created outside of the plant, that's your changing your CBD into Delta 8. It basically creates an intermediate hemp-derived cannabinoid product that can't exceed a total of 0.3% combined total of THC, including THCA, and other cannabinoids with similarly or marketed effects. This is going to be determined by HHS and the FDA later, so we don't know what those are yet. And any final hemp-derived cannabinoid products that exceed 0.4 milligrams per container of total THC and other cannabinoids, and that's combined. So that again is a very low percentage of these THC and intoxicating cannabinoids. The definition of industrial hemp basically is pinned on the use. If you grow hemp for stock or the fiber, seed products like grain, oil, cake, microgreens, or edible hemp leaves, for research purposes, so that doesn't enter the stream of commerce. If it's just for research, then it's industrial, or viable seed production for industrial hemp. Again, if it's not from a plant that is over 0.3%. Defines three terms very specifically: hemp-derived cannabinoid product, and that's basically anything that is used for topical inhalation or ingestion that contains cannabinoids. It defines an intermediate hemp-derived cannabinoid, non-final forms not intended to be sold to the consumers for further processing. And then container, which is going to be an interesting one to look out for. The FDA is going to refine what this means. Right now, it is innermost retail packaging in direct contact with a final hemp-derived cannabinoid product. So if you have a jar or a bottle, any of the gummies or products in there, they all have to meet that packaging requirement of 0.4 milligrams. So implementation timeline for the next 365 days, we have until it actually becomes implemented. In the next 90 days, the FDA will publish a list of cannabinoids naturally produced by cannabis, a list of naturally occurring THC class cannabinoids. So that's anything that is similar to THC or marketed as having the same effects as THC, and a list of cannabinoids or a clarification on what container or means. So exactly what the packaging requirement is. This language is now federal law. I know there's some confusion over whether it needs to be renewed in subsequent appropriation bills, but it has changed the statute, so it does not need to be renewed. It is set to be implemented in 365 days. and the FDA's 90-day timeline is already underway. So we don't know, we don't have a lot of guidance on what the federal agencies will be requiring and what their guidance will be. That's something we will be looking forward to, and we'll update as necessary. Right now, we are continuing with the state program. So everything as is until we change it under the state law. That means the retail and the distribution registration requirements are still set to go live in January. All of the current cannabinoid limits and restrictions are in place for the state. And then once we get the update from the FDA and from the other federal agencies tasked with giving us guidance, we will probably have another webinar and open this up to discussion on where we go with the state hemp program. But right now it is the just keeping with the state law as is. So with that in mind, we are going to go through the list of proposed changes. So this is generally everything that we have added or changed pursuant to Act 269. We amended some of the definitions, and you'll see, we'll give you this list of proposed changes too. This is basically categories of changes, all of the sections of the rules that you'll need to see, and the pages that you'll see them on. So this is all of the definitions that we have added or changed. We changed the THC content limit for tinctures. They are now allowed to be full spectrum. We've added restrictions on ingredients for edible manufactured hemp products. We'll go over the specifics in a second. Change some of the requirements for bulk manufactured products. Bulk really only applies to the processors. If you're just a retailer or a distributor, you can't buy bulk or use bulk. It's only for repackaging or for further processing. But we changed some of the requirements there. We've added new sections relating to the distributor and retailer registration products. So we've added definitions of what a temporary event is. So you can do pop-ups and yearly events. We have added new sections related to the display of certificate of registration and distribution. Added some enforcement sections around suspending or revoking a certificate of registration, so you'll know when we can pull it. Added new sections requiring due diligence. If you are a retailer or distributor, you do have to make sure that your products still meet the requirements, the state requirements to be sold. We added age gating for tinctures specifically. That was something out of the statute. And something about the retailer and distributor operations. We changed some of the overall application processes for processor permits, updated permit applications, updated registration applications, updated the fees. And then finally, we did update the enforcement provisions also. Inspection and enforcement here. So these, again, this is all a general overview of the category, the section you'll find them in, and the pages. So if you have a category you're interested in, and you can just go right to the page. Now I'm going to kick it over to our Greg Edwards, and he can get into the actual details of our proposed rules.
Thank you, Andrew. Hello, everyone. Let me start sharing my screen here. As Andrew mentioned, he did a great job with that summary list of the amendments. I'm going to be going over the actual sections that you'll see them. Anything that's underlined is new proposed language. Anything that is struck through, or you see a line that's through existing language, is proposed to be removed. This is not what we're going to be showing you or going over now are just, again, the proposed changes in the current rules. So the first section here, we're going to be going over the definitions. As Andrew mentioned, very important. to know your definitions, not just the new ones that we added here, but all of them. While most of them are applied to the hemp processor, the company that's making the product in Hawaii, with respect to selling them and labeling, and a host of other reasons. You're going to want to familiarize yourself and understand the definitions. It'll make things a little bit easier as you go through the rules. So certificate of registration simply means that the certificate that the department authorizes to sell manufactured hemp products. And you would be known as a registrant at that point once you complete your certificate. There's two types of certificates. There's a manufactured hemp product distributor, which is defined as the person selling the hemp product to the retailer. There's also a certificate to be a retailer, which means the person selling the hemp product to the consumer. So the retailer buys from the distributor, the retailer sells to the consumer. And of course, distributor sells to retailers. So important to keep in mind when you're going through the application process and reviewing the rules, what activity you're applying for. You will need to apply separately if you're going to be both a distributor and a retailer. Registrant, again, just means you're the owner of the certificate. The registry, this is a database that the statute requires that we maintain. So once you're on the registry, it'll be a public-facing database where the public can see who's on the registry and who's gone through the process of obtaining certificates. Definition of selling. Essentially, it's anything. It doesn't have to be a transaction involving money. So whether cash is actually paid for or not constitutes the sale. And it encompasses anything that's hemp related, hemp biomass, crude, manufactured hemp products. Andrew alluded to temporary event. Temporary events will be those that occur infrequently, occasionally. This would be like an annual event, a one-time event at a pop-up, at a retailer that you may want to have. You would apply as a temporary event. You would pay the $50 fee, and it would be valid for the days that you're holding that, infrequent event. If you're a farmer's market, something that's held frequently, daily, weekly, on a monthly basis at the same location, we would consider you just the same like any other brick and mortar retail location. So that would be a $50 fee, and that permit's good for 5 years. So the difference here is the frequency in which the sale is occurring in that particular location. So infrequent sale at a particular location will be a temporary event. Something that happens consistently on a monthly, weekly basis would be considered like any other retailer. Tincture, this was in the statute. This was something that the industry had put this information in here and the legislature accepted. It's an oil-based unflavored product, contains no more than 1 ounce per container. So a maximum amount is 1 ounce, and it's allowed to have up to 0.3% total THC. The trade-off here is these products, and we'll go into this a little bit later, need to be age gated. So the retailer needs to look at a government issued ID to ensure that the consumer is over 21. The other trade-off is if the retailer is selling tinctures, they do not have to obtain a registration. There's one of two categories. Tinctures and topicals do not require a registration. If you're selling gummies, beverages, other edible forms that are allowed, you will need a registration. So we'll talk a little bit about the changes to the edible manufactured hemp products. You'll see some strike through here, which was just removing from the previous version or the current version when some of the requirements were to take effect. These dates have since passed. The tinctures, again, as we just mentioned, will be raised to 0.3% in a 1 ounce container, a maximum 1 ounce container. Just want to call your attention to this section here. See if I can highlight it. Gummies. This has been moved to another section. So the gummies are still 1 milligram per gummy 5 milligrams per container. So when you see the strike through here, we don't want you to interpret this as this a requirement has been removed. It's just been moved to another section, which we're going to go over in a minute. And it's right here. So the gummy has been added to the list of other hemp products that are limited to 1 milligram per serving and 5 milligrams per package. Some clarifying language here that if you are, whether you're selling or you're a processor, you're a retailer or processor, distributor, that your manufactured hemp product in Hawaii is using ingredients that are allowed to be used in the food supply already, or they're allowed as a dietary supplement under FDA's regulations. If you're going to use one of those ingredients, then they must be purchased from a company that is using the appropriate GMPs, the federal GMPs. So if it's a supplement, you got to purchase it from a company that is complying with this regulatory GMP. If it's a food ingredient, you would be purchasing this from a manufacturer, food manufacturer that's complying with Part 117. There's some packaging requirements, which really applies to some relaxation of the packaging requirements, which only really applies to the hemp processor. So if you're a retailer or distributor, this wouldn't apply to you, but this is a change allowing bulk products that a processor may be able to purchase or sell to not have to comply with the child resistant packaging. This next section, again, is specific to hemp processors that are allowed to sell products for sale outside the state that are otherwise wouldn't be allowed for in-state sales. So there's some changes here that, again, if you're on the call and you're a hemp processor or you're thinking of becoming a hemp processor here in Hawaii, you're going to want to look at this section to know how these changes impact your operation. And similarly, for bulk manufactured hemp products, as I alluded to before, there's some record keeping requirements that we added and relaxed a child resistant special packaging requirement. Again, for hemp processors only. Retailers and distributors are not allowed to purchase and receive bulk manufactured hemp products. Sorry, a lot of scrolling here. And that's what this section here is talking about, some of the record keeping requirements that the hemp processor would need to ensure that they're doing just some due diligence, that they're selling products to a state that allows it and who they're selling it to. Okay, this section is basically the biggest section of the proposed amendments here, which is basically codifying what the law now requires, which is a distributor and retail registration. So you'll see a lot of underlined. It's a whole new section that details the steps by which a retailer distributor would go through and apply to get their certificate. This does begin on January 1st, as we've mentioned. There's a $50 fee. There's a small processing fee with each application. For hemp processors, just want to call this out. If you are already a hemp processor or you're going to be a hemp processor, you will get a certificate of registration without having to pay the $50 fee. So that'll be basically bundled into your hemp processor application fee. So that's something that hemp processors are allowed. There is an exemption here, as I mentioned earlier, if you're selling oil-based tinctures or topical hemp products that comply with all of our Hawaii rules, testing, labeling, packaging, you do not need to get the certificate of registration. If you're selling any of the other allowed products, your gummies, your beverages, your soft gels, your tablets, powders, you will. Shipping carriers are exempt from this as well. So if you're, anyone that's shipping these products on your behalf, do not need to get a certificate. Basic business information here. that will be asking, individuals that's applying, the name, the mailing address, et cetera, Hawaii tax ID, trade names. Um, we will be asking for a list of manufactured hemp products to be sold. Oh, sorry, I can't highlight that easy. It's number 12 here. We're not asking for the specific brand names if you're a retailer and you're selling, or you're a distributor and you're selling. It'll be listed as the types. Are you selling gummies, beverages, tablets, powders, topicals, et cetera? So it's not a list of each brand of product. It's just the forms that we'd be asking for. There'll be required attestations here to ensure that you understand that you'll be complying, that you're testing to comply with the rules. And if you are the property that you're selling from, that the owner is aware that you will be selling manufactured hemp products from there. You'll need to provide evidence that the owner has been made aware and you have permission to sell products there. Information here from 15 and most of the rest of it speaks to temporary events. And I alluded to before, temporary events are those that happen infrequently, yearly, semi-annually, one-time event. You'll need to provide information on where that event's being held, the dates that are being held. Similar, you need to get permission from the event owner that you're allowed to sell these products there. And that's what basically everything that's going on here in this information. There's a renewal application is $50, as we mentioned. There's a small processing fee for this. And the last section here is that the department does not review or approve compliance or other legal or contractual requirements as part of the registration. So you're, as a retailer, distributor, you're responsible for ensuring you're complying with all of the applicable statutes and regulations. Obtaining the certificate doesn't mean that we've vetted all other aspects of law or contractual requirements. Displaying the certificate, just display conspicuously in your retail location, distributor website. You need to display this in a conspicuous manner. There is a process by which the department may move to suspend or revoke the certificate, and there's a means by which the registrant can request a hearing to contest that. And that's information is provided in here, this section. This is all very similar to the hemp processor permit, which is already in the rules. Same kind of opportunities for the hemp processor to request a hearing. Due diligence, and Andrew highlighted this briefly. We just want to ensure that if you are a retailer, that you are buying from a distributor that has a certificate to sell in Hawaii. So retailers need to maintain records that you're only doing business with a distributor selling manufactured hemp products, and those manufactured hemp products comply with the requirements to be sold in Hawaii. Additionally, the second part applies to the distributor. A distributor must ensure that whoever their supplier is, whoever they are buying from, that they are buying products that comply with Hawaii's regulations. This is directly in the law. There's a prohibition on the sale of oil-based tinctures to anyone under 21 years of age. There's requirements here that spell out that the retailer must review identification to ensure that the person is over 21. All right, moving on. I think we did some of this. Yes. Again, similar, there's opportunities for if there's a decision to revoke or move for revocation or suspension, that the registrant has the ability to ask for a hearing. It spells out the opportunities for them to do that here. If there is suspension, then you have to, return and cease operations, return the certificates and cease. So I'm just scanning through some of the big things. Again, we went through a lot of this already. It's just now detailing, not only do you have to keep the records, now it's just explaining how long you have to keep the records for and the information that you are required to capture. There might have been a little duplication in our subset here, but there is some additional language in the rules. This comes directly from the statute, that if you're a retailer, you're going to want to make sure you read through to ensure that your employees are checking IDs properly and the requirements uh, that they need to adhere to. There is a $500 first offense um, for violating this section. Do you want to call attention to distributor and retailer location? So this is where the distribution is occurring, where the sale is, if your retail is occurring. So there's a provision here that this needs to happen. It can't happen in, living quarters in someone's home. It can be on property, but just not have access to the living or sleeping quarters. And this is in line with food, permitting requirements, not only in the states, but across other states. So you have to have your operation of distribution, which is where you would keep your manufactured hemp products, or if it's a retailer location where you're selling to the consumer, just can't be from your home where your living and sleeping quarters are. We made a change here regarding the criminal history information or an FBI identity information summary sheet. I really want to make clear here, this is not for the retailer or distributor to obtain the certificate. This applies only to a hemp processor. We wanted to we needed to create the opportunity for our office to receive criminal history record information or an FBI identity information summary sheet to ensure that the hemp processor doesn't have a disqualifying conviction, which is outlined in the rules. So we updated the rules to reflect this change here. Again, this doesn't apply if you want to be a retailer distributor. You do not have to submit a criminal history background check. Additional information for the hemp processor here when they're applying that they'll need to provide. And I think, Andrew, we're back to you now. We're going to go over some of the new enforcement authorities.
Sure, I'll hit this real quick. Basically, the enforcement aspect includes inspection. We already had the ability to embargo or detain the product, and then it adds seizure. So these are all things that were included in the statute in Act 269. The inspection authority applies to anyone that is either registered or not registered and still selling manufactured hemp products. That allows us to do an inspection to make sure that you are, well, if you're registered, that you're selling compliant product. And if you're not registered, confirm that you are selling manufactured hemp products. You can keep scrolling there, Greg. So embargo, the options we would have for enforcement. If you are selling non-compliant product, we can embargo it in the store and have it sit there while we figure out what to do with it. Or if there's a hearing aspect, keep rolling. So we already have this. This was what our enforcement authority was limited to previously. Act 269 adds the ability to seize the products for forfeiture. And basically, we could take it off of the shelves if you are selling non-compliant products. And then we can apply for an order to get it destroyed. So, obviously, we will work with you. We want compliance. We don't want to just be taking things off of the shelves. So part of this education effort is to let everyone know what we're doing. We're going to do some touch points and go out and do inspections. And this won't be, the initial line of enforcement, but this is an authority that we have been given by the statute. The authority to inspect and seize also extends to the Attorney General's office and to local law enforcement. And so all of the vendors online and vendors in the state that are selling non-compliant product will be able to actually have a better control over it. And so that's the end of our proposed rules. We did get a couple questions that I will go over, but just to reiterate, the idea here is for you folks to take a look at these proposed rules, to read the language, given our stated intentions for how everything is supposed to work together. Um, do the rules reflect that? Are there wording in the rules? Is there requirements of the rules that would be difficult to implement on the industry side? Those are the things that we are looking to understand. And so we will follow up this webinar with emails to everyone that has registered. They will include the proposed rules. There will be the watermark noting that they are proposed. So don't, again, take these as the new rules. These are just for comment. So we will also include a link to an online form that you can submit your comments to. So again, be as specific as possible is helpful. And just like the actual formal rulemaking process, we're really only looking at these changes. So if these changes make sense to you, but you have suggested other changes, you can follow up with that in a separate email. But the form is only to address the draft changes. So going over the questions that we got so far, and feel free to pop some in as we talk here. Were the fees lowered? Can they be lowered to free for farmers with a USDA license? So the fees are $50. We're just talking about just registration for retail and distribution. The fees are $50 for a 5-year period. That's in statute. And if you are a processor, if you are a permitted processor, then you have no fee for at least one retail, one distribution, one website. Those are all free for as long as you are a permitted processor. Now, becoming a permitted processor, if you are a USDA licensed grower, does cost you money. That is set in statute. That's something that we can't amend in rules, but that's something that we could take a look at in the legislative session. Question 2, when will the proposed amendments be available for public view and comment? Like I said, so after this webinar, we're going to email everybody one copy and the form, and we are also going to post it on the website, the landing page, and then at the industry communications tab. Are growers considered processors, or are we still considered researchers? So this might be in reference to the previous hemp pilot program under the 2014 Farm Bill. I know this gets confusing. That was only a research program. After 2018, when we moved into a commercial hemp space, we don't have that anymore. So if you are a USDA grower, you are licensed to grow. After harvest, if you are going to use that biomass that you've harvested in any way to process it into a further product, then you would need a processor permit. So you need to apply to us, get a permit. And there's a lot of things. Again, we went over this in the old webinar, but there also is guidance online about this when you need a processor permit. I mean, if you are relabeling, you need a processor permit. If you are repackaging, even if you send it out to be processed and put into packaging and then given to you and you put labels on, you still need a processor permit. So all of that is contained in guidance. If you have any questions, let us know. If we have a USDA hemp certification for 3 years, do we still need to register yearly for certification? Yes, as a processor, you will need to get a yearly permit. As long as you have that yearly permit, you will have the option to get a retail and distribution registration certificate. But the permits are yearly. If you do want to just get a standalone retailer or distribution certification, you can do that also. And that would be good for 5 years. But as long as you have the permit, you have to renew the permit, processing permit every year, and that will come with it. Um, if stores selling tinctures with THC aren't on the registry, how does that monitoring enforcement process differ from those on the registry? So, I mean, that's a great question. The ability to sell tinctures without being registered was an industry ask. That's something that the legislature included. Um, we will have to, just like we do with any hemp enforcement that's not registered. So the idea of having a registry was there's a list of places that are trying to comply with the law that we can go out and talk to and have touch points with and inspect and educate and all the things before some kind of enforcement has to happen. If you are not registered, then we have to go by complaints and by inspections. So we still would have the authority to inspect and make sure the product you're selling is compliant, and that you're only selling tinctures and only selling topicals without being on the registration. But that will be the um, enforcement mechanism. Question 6 seems to be on the federal banning total THC, THCA, and Delta 9 THC to less than zero point 0.4 milligrams will remove some of the best medicines from the shelf. Will the dispensaries start carrying these products to meet patient needs? That's a great question. I mean, we'll see what happens in the next year with the federal law. I'm getting the indications that it's probably going to not change. So the federal law is likely what we're going to have to be working with. There probably will be attempts to change it, but we have to kind of figure out as a state, as an industry, as a regulator, how we're going to move forward with this. Uh, Definitely, I mean, I've seen a lot of different market analysis that's saying people are wanting the more low dose products. So dispensaries maybe start carrying more of those. That's basically a commercial, industrial decision that they have to make, a business decision. But we would like to see that too. Question 7, is there a potential $500 fine for not carding for retailer sales of tinctures? Yes, there is a potential fine for not carding. It does escalate, and the details are in both the statute and the rules. I think the rules we just copied and pasted from the statute. So if you want to change that, that would be a legislative change. If you want to confirm that, you would look at Act 269 and the rules that we are drafting. Just make sure that they're the same. Another pair of eyes on that never hurt. Um, what is the process OMCCR will take to enforce latest rules for online retailer? So there's a couple different enforcement options for online retailing. We've already started reaching out to online folks and people that are um, importing things. We've invited them to the education events, and this is part of everything. Everything is, if you're selling here, if you're selling on the mainland, if you're importing, if you're online, you have to comply with our rules. We do have different enforcement mechanisms. We will likely start sending out cease and desist letters, and we also tapping other resources like the Attorney General's office and other law enforcement to, you know, also help us with enforcement. My goal is to do it on the civil side, to send cease and desist letters, to use fines, to use administrative enforcement penalties, and not escalate this into a law enforcement situation. That's what I would like to see. So that's where we are working towards. It looks like there were no other questions submitted. So with that, if you have any other questions that pop into your head as you are reading the rules or as you're thinking about what we've discussed and the federal law and all the things that go into it, feel free to email us. We're going to send you out the proposed rules and a link for commentary on that probably this afternoon or tomorrow. Greg, did you have something to add?
Sorry, yeah, did you go over the form that they can submit their questions on the rules that'll be up?
I did not.
Give me a second. I can find that really quick here just to show you what the link will look like. Okay, I'm going to share my screen here real quickly. This is going to be the link. It'll be on our main page, our main landing page for our hemp products. And it'll also, well, that's where you access this link. Can you guys, Andrew, can you see my page?
Not yet. There
All
you go.
right, there we go. And so this will be it looks like it's a Microsoft online form to fill out where you would answer, some questions here, initial questions, and then give you an opportunity to pose your comments after you review the rules. Let me just see what happens here when I do this. So you can see, please provide the sections of the draft rules that may directly impact your business. We give you examples of those sections here. So very straightforward. And then you can submit that and we will collect that information. And Andrew, it's 1 week, correct?
Yes. So you have a full week to read and make comments. This is an online form, so you might want to make a comment or, draft it up in Word or something so you can cut and paste. That'd be the easiest. That's what I would do. So,
Great.
but we will receive all of these and use these to inform us in finalizing the draft rules. So again, we're hoping to get your perspective on this. All right, folks. And if that is it, then thank you for attending. We do appreciate all the engagement we've had on these as we try to actually listen to the industry and discuss what we're planning on doing. So be on the lookout for the emails and for more updates in the future. Thank you very much.
Thank you.